We're going to turn now to Eric over in Center Point. Eric, so glad that you're watching us this evening. How can we help?
Divorce was finalized last year, and Mom has violated the divorce decree. I have pictures of abuse to the kids, but no one is really taking it serious. She took them out of town without my consent and wasn't able to talk to them or see them for 4 days, but nothing's being done.
And I'm assuming you've contacted authorities in your area?
Yes.
Okay.
So, in essence, the violation of the terms of a divorce decree, which is a court order, are covered under contempt or a petition for rule nisi before the divorce court. It's a civil matter. And so to hold the person who has violated the divorce decree in contempt, it would be you would have to take it back to that court, meaning the divorce court has exclusive jurisdiction over those particular areas. So if Mom, your ex-wife, violated some provisions of that decree, especially dealing with the children, your remedy would be to go back through the court system through which your divorce was adjudicated, meaning go back to divorce court to get a remedy there. And even though it's a civil matter, if a person has violated a divorce decree, especially if they violated it more than once or over and over again, that person can be held in civil and criminal contempt by the divorce court judge, the domestic relations circuit court judge. So even though it's a civil matter, when violations occur and they mount, people can be held in civil and criminal contempt for those violations. So there is a remedy and there is help for you.
So it sounds like you're saying his first call in the morning needs to be to his divorce attorney.
Right. You need to contact someone about filing something with the court.
And Laura Susan, I know his experience so far has not been good, but our experience, and I'm sure yours, when somebody violates one of the court orders, one of the judge's orders, especially here in Jefferson County, they do not take that lightly.
You are absolutely right. And we happen to have some great domestic relations judges in Jefferson County right now. We have wonderful judges, and they take their orders very seriously. As I tell my clients all the time, it's a court order, not a suggestion, and it should not be violated under any circumstances. So I think that you've got a remedy.
Yeah, that's all good information for you. So Eric, hopefully that helped. We're going to head now back to the phone lines. Have quite a few folks calling in. We certainly appreciate that. We're going to start with Betty over in Roebuck. Betty, if you will, go right ahead with your question.
Hi. First of all, I enjoy your program. I look at it pretty much all the time.
Thank you,
Look,
Betty.
what do you do when you go to child support? The mother takes you to child support, and they won't let you bring your paperwork, your receipt, or pictures, or nothing like that. You've been staying with this woman for a long time. And so they hardly want you to let you speak. All they want to know is how much you made. And then that's what they base the child support on. Now, you don't have enough money to get a lawyer, so what do you do?
Laura Susan, good question.
So if I understand your question correctly, Miss Betty, you're saying that it's a mother trying to recoup child support, unpaid support for her children? Is that the perspective?
No.
Oh.
She's taking the child to child support and taking the dad. She's taking the dad to child support without his knowledge until he got ready to receive the papers. Once he received the paper, they went to court, but they wouldn't let him bring none of his paperwork where they were staying together, receipts and all that kind of stuff, pictures and all that. They wasn't interested in that. All they want to know is how much he made. He had to show how much he make per month, and then they based the child support on that. But once they started doing that, he didn't have money to get a lawyer, enough money to get a lawyer, because in South Carolina I think it's $200 to $300, per hour or something like that.
So
what do you do?
Well, in that scenario, obviously I tell everyone that I come in contact with, try as hard as you can not to go to court without counsel, because it's very important that you have a lawyer represent you. But if you can't afford a lawyer, child support is based on just a few things under the Rule 32, which is the rule that governs child support. But it's based on the child, how many children there are, who pays medical insurance cost, daycare cost, out-of-pocket daycare cost, things of that nature. And it's based on how much money each of the parties make. And then it's computed into a formula. And so basically the order for child support is based on how much income, if the father is ordered to pay support, that the father is earning, and how much income the mother is earning, and some of the expenses for the child. And those things are computed and computed under the guidelines, and we're given a number at that point. So if I'm assuming this is a relative of yours, if he has a dispute about how much money he is making, things like tax returns are important, W-2s, 1099s, anything that he can show where he's making more or less than what is being alleged that he's making will help him get an accurate number on that child support.
And what if the parents are still living together? Is child support then still required?
Sometimes in family court where the parties aren't married, child support can be calculated when the parents are still living together. And in divorce, child support can be calculated when the parties are living together in the temporary, what we call a pendant light situation. Okay. So, obviously, yes, people are supposed to support their children, and that's mothers and fathers are supposed to support their children, and that can be awarded no matter what the living circumstances are, okay, depending on the specific facts.
Excellent. Okay. Well, Betty, thank you so much for calling in tonight to ask your question. We certainly appreciate that.